A competent witness is a person who is legally capable of giving evidence before a court. Under Section 124 of the Bharatiya Sakshya Adhiniyam, 2023, formerly Section 118 of the Indian Evidence Act, 1872, every person is competent to testify unless the court believes that because of tender age, old age, disease, mental or physical disability, or any similar reason, the person cannot understand the questions or cannot give rational answers. Thus, competency depends on the ability to understand and answer, not on age, gender or relationship. 1. Who is a competent witness? A competent witness is one who understands the questions asked by the court, gives logical and rational answers, can correctly remember and narrate facts, is capable of communicating the truth. The law starts with the presumption that every person is competent. Only when the court finds that a person cannot understand or answer properly is that person treated as incompetent. 2. Whether husband and wife are competent witnesses against each other in criminal cases? Yes. Under the Bharatiya Sakshya Adhiniyam, 2023, the husband and wife are competent witnesses in criminal proceedings involving each other. Their marriage alone does not disqualify them from giving evidence. However, there is an important protection. Private communications made by one spouse to the other during marriage are privileged. Such confidential communications cannot ordinarily be disclosed in court without the consent of the spouse who made them, except where the law specifically permits disclosure, such as disputes between husband and wife or certain proceedings. Example: a husband sees his wife committing a theft. He may testify about what he personally saw because it is an observed fact. But if his wife privately confessed the theft to him during marriage, he generally cannot disclose that confidential communication without her consent unless an exception applies. Thus, a spouse is a competent witness. 3. Can a dumb, speech-impaired person be a competent witness? Yes. A dumb or speech-impaired person is a competent witness if the person understands the questions and can communicate answers through writing, signs, gestures or any other understandable method. The court may take the help of an interpreter or a special educator whenever necessary. The inability to speak does not mean inability to give truthful evidence. What matters is whether the witness can effectively communicate and the court can understand the answers. 4. Can a minor be a competent witness? Yes. There is no minimum age fixed by law for becoming a witness. Even a child can be a competent witness if the court is satisfied that the child, before recording the testimony, the judge usually asks a few simple questions to test the child's intelligence and understanding. This is called a preliminary examination. The evidence of a child witness is valid. However, as a matter of caution, courts carefully examine whether the child has been tutored or influenced by others. Case study, Rameshwar v. State of Rajasthan, 1952. In this case, the conviction was mainly based on the testimony of a young child. It was argued that a child could not be relied upon. The Supreme Court held that the evidence of a child witness is not unreliable merely because of age. If the court is satisfied that the child understands the duty to speak the truth and gives trustworthy evidence, the conviction can even be based on such testimony. The court added that, as a rule of prudence, corroboration is desirable in appropriate cases but is not always legally compulsory. Conclusion: a competent witness is any person who can understand questions and give rational answers. Husband and wife are competent witnesses against each other in criminal cases, though confidential marital communications are generally protected. A dumb person is also competent if able to communicate effectively.